I think you're all set.
All set.
Okay, 5:05. Tad is absent due to illness, but we still have a quorum because there are three of us. So the first thing we're going to do for our meeting is if you guys review and approve the minutes of the 12/1/22 portion of the hearing. And if you don't want to do it because Tad is not here, that's, we all had, he sent us all.
Chance. I can move that we first meeting, the Board of Adjustment and Appeals.
Did you have a chance to review them, Charles? Okay, then we should not.
We should wait.
Let's wait till we can get Tad. Okay, here, so, okay. So the next thing on our list. And we received several letters within the 10-day window asking the board to reconsider our 12 December 1st, 2022 decision. And this one is from George Hayden with us on the resource protection.
Do we need to read them or?
Do you want to read them?
I don't know. I just don't know if we need to.
Did you read them beforehand, right, Charles?
But to be part of the public.
To be part of the record.
Okay, so dear Town Schvig, I would like to request reconsideration of the Board of Adjustment and Appeals decision, interpretation of the Coastal Bluff map, shoreland zoning ordinance appendix B was incorrect. I've lived on Cottage Road for many years, and there is a distinct break in the coastal shoreland between the Oderda and property, which means that there are no coastal bluffs at the McKee's property. In fact, the shorefront, the notes of the coastal bluff map say beaches and dunes do not form bluffs, except along the seaward dune edge as a result of erosion. This map does not identify erosion trends on beaches or sand dunes. So not only does the decision seem wrong, but because the decision comes after construction is largely complete, the cost of this decision could be in excess of $1 million of liability to us, the taxpayers of Schwig. I am sorry that new construction often changes the ocean views that people have come to enjoy over the years, but it's not their land. They don't have to pay the taxes on it. They have no right to try and start a homeowners association of island properties. Thanks for considering my thoughts. George Hayden, 71 Cottage Road. So you want to?
That was Appendix A.
That was Appendix A.
I can read Appendix B.
Yeah. On the recording, no one will be able to hear it. Thank you.
Appendix B is a memo to the Board of Adjustment and Appeals from Jim Butler, the Code Enforcement Officer. And it's a request to the Board of Adjustment and Appeals to reconsider their decision. And it reads, You are hereby notified that I am officially requesting that the Board of Adjustment and Appeals reconsider their decision pertaining to the Board of Adjustment and Appeals appeal permit NP 22 SC-2 located at 107 Cottage Road, Town of Big Island, tax map I-03, lot 14. This decision was made on December 1st, 2022. Under Maine State Statute Title 30-A, Section 2691, Section 3-F, the board may reconsider any decision reached under this section within 45 days of its prior decision. A request to the board to reconsider a decision must be filed within 10 days of the decision that is to be reconsidered. A vote to reconsider occur and be completed within 45 days of the date of the vote on the original decision. The board may conduct additional hearings and receive additional evidence and testimony as provided in this subsection. That's quoting the ordinance, the state statute. There are many items that the board asked for, including legal opinion on the shoreline zoning ordinance, questions of the property owner, questions for the appellant's legal counsel, and additional questions of the code enforcement officer. The board did not allow for any of those things to take place, and in which I believe the decision was made prematurely and inaccurately. Additionally, the finding of facts had been pre-prepared and rehearsed. Additional testimony and facts need to be heard by the board to allow for a fair and accurate decision. Respectfully, Jim Butler, Code Enforcement Officer, Town of Big Island.
Thank you, see, Charles.
Yeah, and then from Michael and Mary McKee, Board of Adjustment and Appeals, we respectfully request reconsideration of your decision to reverse the Code Enforcement Officer's approval of a shoreline project permit application for driveway extension in Guest House site 22SC-2 made on December 1st, 2022. On November 17th, the BAA voted to continue, not close, its public hearing because the board felt it was missing critical information required before it could reach a decision. The additional information was requested from the town attorney, the code enforcement officer, and the property. We attended the December 1st hearing and were prepared to present the requested information along with other important material. However, we were not given the opportunity to speak or present. We believe that we have been denied our due process to be heard during the de novo review of our shoreline project permit. We are especially concerned that the appellant's attorney was able to submit a response, Appendix G of your decision, on December 1st, but we were not afforded the opportunity to present. The BAA has taken great care to ensure that the appellant's right to due process is not denied, yet has denied our right to due process. We consider the submission and your acceptance of Appendix G as ex parte communications and continues to demonstrate a bias against us. Under Maine State Statute Title 30A, Section 2691, Section 3D, every party has the right to present the party's case or defense by oral or documentary evidence, to submit rebuttal evidence, and to conduct any cross-examination that is required for a full and true disclosure of the facts. We believe your conclusions and findings of fact are in choice, and we are prepared to provide additional evidence and testimony. Thank you for your consideration.
Okay, so Appendix D is, the first one's from Don Bucksbaum. Hi, Vika. I would like to request that the Board of Adjustment and Appeals reconsider their decision made at the continued hearing on December 1st regarding 107 Cottage Road. At the conclusion of the November 3rd session, that board voted to allow continued testimony at the next session. At the beginning of the December 1st session, it was announced that the public portion had closed. This did not allow for any further important testimony, which could have changed the outcome. Thank you for your consideration, Don Bucksbaum.
And from David Hill, dear Ms. Wood, Due to the proximity to my niece's and her husband's property, I became interested in the Board of Adjustment and Appeals actions concerning the Mackey property at 107 Cottage Road. I attended the first hearing and watched the second hearing on Zoom. The decision rendered in that case appears completely flawed to me. I urge the town to reconsider this decision and reverse what I consider to be a total miscarriage of justice. Sincerely, David R. Hill, 13 South Road.
From Nancy Hill, it would behoove the town of Shabby to reconsider the decision of the Board of Adjustment Appeals. I listened to the testimony and cannot understand how that board came to that decision. I have looked over all the information and do not understand the reasoning. I think that the optics of having a board member with a history of complaints about the McKees is grounds enough to disqualify that member from participating. Sincerely, Nancy Hill.
We need to read.
Additional letter?
What about the town attorney's?
We have a memorandum on, I think this is just personal, it just. not
Well, it's part of the
personal,
public record.
It just is Natalie Burns, the town attorney, on December 15th, sent the board, and I believe we got it. The board got it. And she sets forth the purpose of this memo is to set forth the procedures for a request for reconsideration, as well as explaining the statutory requirements and deadlines. Number one, statutory deadlines for reconsideration. 30A MRSA section 2691F states that the board may reconsider any decision reached under this section. There are two deadlines established. The first is that a request for reconsideration must be filed in writing within 10 days after the date of the board's original vote. That deadline has been met by requests concerning the McKee property. The second is that if the board votes to reconsider, it must do so within 45 days after the vote on the original decision, and it also must complete all action on the reconsideration within that same 45-day period.
Want me to read number two? Motion on request for reconsideration. The board will have on its next agenda the requests for reconsideration. Those will be in order for the board's consideration. The chair should ask whether there is a motion on the request. If a motion is made to reconsider and adopted by the board will move on to the following steps. If no motion is made, or if a motion is made and it's not adopted by the board, that is the end of the board's consideration of the appeal under the shoreline zoning ordinance. The decision on whether to reconsider or whether to make a motion to reconsider lies within the discretion of the board. Number three, legal effect of vote to reconsider. If the board votes to reconsider, that action undoes the board's prior vote and takes the matter back to where it was immediately prior to the vote. At that point, the board will determine what action it wishes to take next. Number four, action after approval of motion to reconsider. If the board votes to reconsider its decision, it will then determine what the scope of that reconsideration will be. There are a few different options, and the determination of which option the board follows after a vote to reconsider also lies within the board's discretion. A, in some cases, the board may limit the reconsideration to a review of its decision to correct any errors or omissions. An example of this would be a case where the board had intended to include a condition of approval in a variance or other approval, but inadvertently omitted it from the final vote. Another example would be to clarify a finding or a portion of a decision. In these cases, the board may decide that it will proceed to a new motion or vote without additional hearing, evidence, or testimony. B, limit the reconsideration to one or more specific issues and conduct an additional hearing on that issue, including additional evidence and testimony. C, hold a full new hearing on the matter, allowing additional evidence and testimony without limitation. In his letter dated December 13, 2022, counsel for the appellants urged that if the board decides to reconsider the prior vote, it should limit the reconsideration to the issues set forth in the reconsideration request. As noted above, the determination of the scope of action on the reconsideration lies within the discretion of the board. A reconsideration is not limited to issues raised in the request. Conversely, a reconsideration does not have to address all issues raised in a request. Final decision on reconsideration. If the board votes to reconsider, its final decision may do any of the following. A, readopt the prior decision without change. B, readopt the prior decision with revisions. C, adopt a new decision with new findings and conclusions. 6, notice and scheduling. If the board decides to reconsider, there should be a notice to the parties and the general public. This is done either by making the motion at a meeting and then establishing a schedule for the hearing that allows sufficient time for notice, or giving notice of a meeting where the request for reconsideration will be on the agenda, and including a statement that the board may hold a hearing and accept additional evidence and testimony at that meeting if it decides to reconsider. If the board meets on December 19th and determines that it wishes to reconsider the decision, then my recommendation is that you schedule a subsequent meeting for action as requested by counsel for the Gallaghers and Drews. Number 7, extension of appeal period. If the board votes to reconsider and takes its final action on the reconsideration less than 15 days prior to the end of the current appeal period, the appeal period will then be extended to 15 days after the final action, parentheses, vote on the reconsideration.
December 13th.
Yeah.
Okay. I mean. Sure, but anyway, so on December 13th, we got an email from Keith Richard, who is the attorney for the Jews and the Gallaghers. Says, "Dear Chair and Board, I write in opposition to the request dated December 9th to consider the board's decision regarding permit number 22FZ2. The board should deny the request and uphold the original decision. At the conclusion of the board's November 3rd hearing, there was a request for the town attorney to provide additional information relevant to the issues implicated in the appeal. Attorney Burns provided that information by email to both myself and Mr. McKee on November 28th, 3 days before the meeting scheduled for December 1. Mr. McKee asserts that he was denied due process and baldly alleges bias. We submitted written comment in advance of the December 1st meeting, and Mr. McKee had the same opportunity prior to the decisions being made. Due process requires nothing further. Note also that the law court has upheld municipal board decisions as complying with due process, where the board accepts comments from an applicant without providing the same opportunity for other interested parties, where those parties had a full and fair opportunity to comment on an application. Duffy v. Town of Berwick, 2013, Maine 105, section 1782A.3D148. Due process does not require a party to enjoy unfettered or limitless opportunity to be heard. In fact, only a fair opportunity. See above. The board has discretion to control the manner of accepting evidence and allowing or denying opportunity for rebuttal. See Forest Ecology Network versus Land Use Regulation Commission, 2012, Maine 36, section 3839A, period 3D 74. Friends, board's decision not to reopen the hearing was reasonable and within the bounds of its discretion. Close quotes, close friends. See also Fichter versus Board of Environmental Protection, 604 A2D 433, 438, May 1992. Friends, quote, finding that additional procedures were not necessary when the parties had ample opportunity to present evidence. Close quote. And friends. As to bias, there is no evidence presented to support this allegation. This board, quote, enjoys a presumption of honesty and integrity, which is only rebutted by a showing of some substantial countervailing reason to conclude that a decision maker is actually biased with respect to factual issues being adjudicated. Field versus Town of Stockton Springs, 2017, Maine 6, Section 19, 153A, period 3D, 768. Mr. McKee falls well short of this high standard. An unfavorable decision is not evidence of bias. Even if the board determines that Mr. McKee should have an additional opportunity to be heard, such proceedings should be strictly limited in scope to the grounds set forth in Mr. McKee's request, which complains only about Appendix G, the letter we submitted on December 1st. Accordingly, if any additional proceedings occur, they must be strictly limited to the issues discussed in the town attorney's memorandum dated November 28th and our letter of December 1st that only addressed the November 28th memorandum. The board should not allow for the scope of the hearing to reopen matters that were not discussed in the written materials submitted after the November 3rd hearing. This would include Mr. McKee's reference to, quote, other important material, end quote, beyond responding to the 5 items requested by the Board of Adjustment and Appeals and addressed in the November 28th memorandum. While it is unclear what this, quote, important material, end quote, may be, the point is that the opportunity to present his case was at the hearing on November 3rd, and if there were materials that were important to the issues, they should have been presented at that time. See Victor 604A, period 2D at 438. Lastly, should the board still vote in the affirmative to reconsider its December 1st decision in accordance with section 508.f of the Shoreland zoning ordinance, we would request that the board schedule a public hearing on reconsideration at its next available meeting after the vote to reconsider. Thank you for your thoughtful consideration, and we look forward to concluding this matter. Sincerely, Keith Richard. CC, Michael McKee, Natalie Byrne, Sandra Boulay, James Gallagher, Andy Gallagher, Nona Drew, Jeffrey Bruce, Chris Wilbur.
This one.
The thing that we just,
The one today.
the one that came,
So today's letter from
Yeah.
Sandra Day.
and then we have Mike McKee's response to that letter. I mean, we can read it into the record. Yes, please. I think I gave you, if not, you can make copies of it. Do you want to, you don't have it?
I have it. I got it.
Oh, I'm sorry.
I was emailed.
Oh, do you want to read? Do you want to read
Okay.
the archipelago thing?
Okay. Dear Madam Chair and board members, upon review of the November 3rd, 2022 BAA meeting video and the December 1st, 2022 meeting video, it appears that the board had made a determination to hold the public hearing open at the conclusion of the November 3rd meeting, specifically to have the town's attorney provide guidance on 4 specific issues or questions that BAA had. 1, a better copy of the Owen Haskell plan. 2, what are the dates for non-conforming lots? 3, review of deeds for original lot 7. 4, is the accessory structure in the shoreline zone? On November 28, 2022, Attorney Burns forwarded a memorandum to the BAA addressing these 4 specific issues. On December 1st, 2022, Attorney Keith Richard responded to Attorney Burns's email by letter to this board. Mr. McKee did not provide additional information to the BAA in either supporting of or refuting comments made in either Attorney Burns's memorandum or Attorney Richard's letter. It is my opinion that there is a procedural error here that should be corrected in the event this matter is brought to the Superior Court pursuant to a Rule 80B appeal. Correcting this procedural error now could save the town and the parties both time and money. Should the court determine that the matter would need to be remanded to this board for a correction of the record. Specifically, I would respectfully suggest to the BAA that they vote to reconsider the board's decision subject to the following limitations. The BAA should vote to reopen the public additional testimony to the 4 questions that the board asked the parties to address following the conclusion of the November 3rd meeting. The BAA should then close the public hearing and, using the additional testimony on those 4 points, amend the findings of fact if necessary, and then determine if they change the result of the decision made at the December 1st, 2022 meeting. Mr. McKee argues that he's not resolved at the November 3rd meeting, including the good cause exception for bringing appeal. The shoreline zoning ordinance is quite clear, however, with respect to the procedures applicable to all parties upon the filing of an administrative appeal, and in particular in a de novo appeal from a decision of the code enforcement officer. Mr. McKee was timely noticed that there would be an appeal, and as he stated at the November 3rd meeting, had a full 2 weeks to prepare for the hearing. Furthermore, had he felt that 14 days was not enough time for him to prepare, the ordinance allows for an extension to the timeline for the public hearing, if agreed to by the parties. Mr. McKee never made such a request. All parties are subject to the same rules. The Gallaghers and the Drews paid to have their attorney prepared for the November 3rd hearing and present at the hearing. They paid to have their consultant prepare documents for and be present at the hearing. Mr. McKee could have done the same, but elected not to. He should not be rewarded with a do-over now for what he failed to be prepared for, or to seek an extension for, if that was not possible, on November 3rd, 2022. In summary, while it is of course ultimately up to the members of the BAA, the appellants will withdraw their objections to the board granting the request to reconsider, so long as the board's motion, the hearing, and the reconsideration that follows is strictly limited to allowing testimony and reconsideration based on the board's 4 main questions as outlined in Attorney Burns's memorandum. To the extent, however, that any motion to reconsider opens up the testimony and the reconsideration beyond this limitation, the appellants continue to object to the request for reconsideration as provided in the December 13th, 2022 letter from Attorney Richard. In either event, should the BAA vote to reconsider, we would ask that it schedule that hearing on the reconsideration for the board's next available agenda. As always, the appellants thank you for your thoughtful consideration and look forward to concluding this matter.
I think that's
Okay.
And then we have the McKee's last letter.
okay. Letter dated December 19th, 2022 to the Board of Adjustment and Appeals from Michael and Mary McKee. Board of Adjustment and Appeals. This morning, we received copies of a memorandum from the town attorney dated December 15th, 2022, and a letter from attorney Sandra Guay dated today, December 19th, 2022. Ms. Guay has recommended the BAA vote to reconsider the board's decision to correct a procedural error with limitations on actions following the vote. Ms. Guay's letter substantiates our previous assertion that the BAA voted to continue, not close, its public hearing on November 3rd, 2022. However, we do not agree with the limitations recommended by Ms. Guay. We continue to assert that we have been denied our due process to be heard during the de novo review of our shoreland project permit. For reasons stated in our letter to the board dated December 9, 2022, and the BAA's extensive findings of fact and non-conforming worksheet, which were written between hearings, we believe that we have not been given a fair opportunity to defend ourselves. We believe the BAA has violated the Maine open meeting law, Title I, Chapter 13 of the Maine revised statutes, because your actions were not taken openly and that the records of their actions be open to public inspection and their deliberations be conducted openly. When you discussed, debated, and pre-wrote your findings of fact and non-conforming lot worksheet between public hearings. Furthermore, Maine's open meeting law is intended to protect citizens from clandestine meetings, conferences, or meetings held on private property without proper notice and ample opportunity for attendance by the public, which you obviously held. We deserve the right to openly refute and/or provide evidence that contradicts your findings of fact and non-conforming lot worksheet. Sincerely, Michael and Mary McKee.
So I'd like to just briefly address the issue of that there was some meeting that we had. I didn't meet with anybody. I didn't meet with anybody. Sam came here with some, notes that she distributed to us. If you recall from the meeting, I didn't actually read them because I listened while she read, and that was our deliberation. She was reading her work product that I had not discussed with her. I hadn't discussed with anybody. So, I felt that it was a mistake to read them the way that they were being read because that could give the impression that that was the things were decided. It's supposed to be deliberations. We're supposed to be talking, not reading, our work product as if it was the product, from another meeting, right? There wasn't a lot of disagreement. There wasn't a lot of disagreement because it doesn't seem that there wasn't a lot of disagreement because we didn't disagree with each other.
Right.
And that could be necessarily because of conclusion. That's kind of the cynical. The other could be that, these issues aren't that unclear and that the testimony that is pertinent to these issues is the testimony about the actual facts, right? And a bunch of those facts are not entirely clear. And this last letter is very persuasive to me. A better copy of the Owen Haskell plan. What are the dates for non-conforming lots? It took all of us working individually because we couldn't talk to each other to figure out what it meant. And then after the meeting, we were like, okay, after the meeting, okay, we can talk about it. But so I really do. I would like to make a motion to reconsider. And I would like to, I think the one way to look at that is if we limit it to these 4 topics, that we're somehow biased against archipelago. But I'd be willing to make a motion if we are limiting it to the facts that are pertinent to the
The things
issue.
we asked for at the previous hearing.
Yes.
Right.
In any element that is in, for you to win, you're supposed to counter, the appellant is they've made out an argument, it's all on paper. You have to address what they are saying, not doesn't matter. It seems like your argument was you were doing what the code enforcement officer told you. A lot of our facts were, a lot of our stuff, our conclusion was that guy made mistakes.
Well, the whole.
That he did not create a file that could support the issuing of a permit. And in a way, yours doesn't contradict that. Yours is saying, hey, I did all the stuff I was supposed to do, and boom, I got run over by a truck. So as far as it's hugely emotional, this stuff. It was hugely emotional. I understand it's very, this is a difficult thing, a very difficult thing for a small community. And it does appear, it's gonna go to court. And that is a good that's a good place for it to be adjudicated. If we're, at this level, there are some, if we keep it to the facts and stuff like that, as far as how do you provide justice in this situation, that's really beyond the scope of this board. We're about some facts and stuff that's gonna go somewhere else.
Well, yeah, and what we are charged to do is a de novo review of the application for a permit, which means beginning anew. So we have to go through it as if we were issuing that permit.
Right.
Right?
And then the board chair, as Peter Rice always did for us, prepared pre-hearing findings of fact. We went through them, so each hearing that we had with Peter, which was many years worth, and we threw out the ones that weren't relevant and introduced ones that may have been omitted by Peter. And usually we dealt with pretty straightforward things like a variance. You only need to meet those 4, like undue hardship, all that stuff. So it was usually pretty cut and dry. This is anything but cut and dry. We decided the good cause thing at the initial part of the hearing, as the town attorney instructed us to do. And I have to say, I think some of the confusion here has been caused by the town attorney. I closed at the first hearing on 11/3/22, I closed the hearing to public comment at hour 3, minute 14. No one had any more comments. It was now closed to public comment. And then Natalie and said, you probably have some questions for us. So, well, we were opening up a mayor's nest.
Well, not necessarily.
Or
I mean,
potentially.
there really were only 4 things that were asked for, and when you have the evidence presented to the board, all parties need to be able to present the evidence and question it.
Right, but we were pretty clear, once you close a hearing to public comment, we can ask for additional information. It does not necessarily give anyone the right from the public to ask questions. We can ask questions of you. You can ask questions from.
I guess I would differentiate between the parties involved, the appellant, the applicants.
But anyone, the public.
No, I would differentiate because I think if new evidence is brought to the board, that the parties should be allowed to question it.
Well,
It was in our class.
But we gave them ample opportunity.
At the first meeting.
Yes, and then we closed it.
But then we got new evidence and nobody was allowed to comment on it. So I think that reconsideration is appropriate.
Of those 4 things.
Yeah.
So that jettisons the George letter. I mean, it basically only covers she gave us her answers.
Yes.
And then the other lawyers responded.
To me, the main issue brought up by the letters for asking for reconsideration, the main issue was that evidence was brought forward by the appellant's attorney, the town attorney, by our own research, okay? And the request for reconsideration was that no one had the chance to question or comment on it.
But the point of due process in a public hearing is that's when the appellants and the permittees get to comment in a public forum forum. The code enforcement officer gets to weigh in, and apparently the town attorney gets to weigh in. Everyone asked every question they could think of, and we then close the hearing to public comment.
Yeah, and as soon as you
Right,
said,
but we also have the discretion to do whatever we want as far as.
Absolutely,
As, you know, it's mentioned in the letter, and
right.
And so we also have this procedural, potential procedural error. And so I think if we didn't open it up, we don't have to do anything.
Now,
We
let
can
me-
open it up. You know, we can reconsider. And then we don't have to change anything. But we will reconsider, take some testimony. And
Well, but
then,
then whose testimony are you going to take, Charles? Because, and when are you gonna cut it off? Because wait a minute, maybe they're being denied due the process if you cut them off. Like, it's a slippery slope. Let me read what Tad sent to us, because Tad is quarantining or isolating or something. So he said, been trying to put together my thoughts regarding the requests and share them with you prior to Monday's meeting. As is a habit with me, I drafted many pages of notes, lots of reasons. If I'm smart, I let them sit and then I start reducing them. Let me summarize first, that none of the requests for reconsideration of our December 3rd hearings decision be considered. That Cheryl's motion to revoke the shoreland project permit application based on 3 ironclad, irrefutable findings of fact she chose makes any of the proposed reasons for reconsideration null and void. Our decision could have included many more, including my pet one, the shore frontage issue. However, Cheryl had the forethought to keep the motion simple and unquestionable. There are certain written rules / ordinances, and we have been appointed to be responsible for making sure when they are challenged or avoided, that they are adhered to correctly or eventually. 3 of those were not adhered to, and we ruled based on them. None of the letters challenged the validity of those 3 findings and our conclusion. Do we need to justify our decision to not reconsider any more than that? I would argue no.
did he write that before he got the December 19th letter from Archipelago, from Sandra
I
Gay? And I
can't
do
say.
believe it's Gay. Most of the people I know it's GUA. They do say Gay.
Oh, okay.
okay,
You can say Gay.
Well, not
okay.
in Florida.
You can hear.
Oh, okay.
I think what Tad was trying to say was that the final motion that we made was that the permit be revoked because it was lacking 3 things that the ordinance says you must have. One is a scale drawing. The second is a,
Scale plot plan.
yeah,
That way the building would, why is the building not where, you know, why are we wondering where the hell the building is?
right.
Because there wasn't a scale plot plan. Why are we wondering, you know, any of this stuff? Because this wasn't handled the way that it should have been handled. But there's like, the very first question that comes up in all of that is the one of, you know, is it a non-conform, you know, is that a non-conforming lot? When it was, of course, we were told, well, we can't get into that, but it came up, again here with what are the dates for non, I guess that's the dates for the shoreline zone for non.
Right. But there are 2 ordinances that have to be considered, and the more restrictive one applies.
Because there's obviously overlap in them, even though we were told by our town attorney that there's no overlap. So that's one of the problems with it. I am with Tad. I think we had an ironclad decision. We cited deficiencies in the application and the acceptance and
Right.
the issuance.
And
So
yet
I don't
this
think we
lawyer
need to-
right here who's at the actual appellant, is saying, we could save the town money, and we could save the,
You know, that's
we could
not
save the other
our, that's
people.
not our
We could
bailiwick.
save the, I don't know that that isn't.
No.
Where do you live? I don't know that that isn't.
We don't, our bailiwick is not to consider who saves what money for this. We're just supposed to be
We
reading
have-
the ordinance.
We
and
have
interpreting
both
them.
of the appellants here saying, we'd like you to reconsider it. We have both of them, okay? The McKees want to reconsider. The
Okay, well,
attorney for the appellant wants to reconsider.
duly noted.
I don't know of any public interest we have in, insisting on an adherence to a rule when both of the parties are saying, and it may be expediency for us, so we don't have to deal with this anymore. But I don't see the public policy interest in doing that. And I think it can undermine the legitimacy of our board. So what, it's gonna mean another meeting.
Yeah, I agree. And to me, it's like, I mean, yeah, we could act like a court, but if there's information that is pertinent to what we voted on, I'd like to hear it. We haven't received it.
We actually already have received it. According to Keith, Richard, and to Natalie, I watched that video again, rewatched it, and it's limited to the 4 questions.
Yes.
So we got answers from Natalie on those.
Right.
And
Natalie's,
then Keith, Richard answered for memorandum.
Yeah, but we don't want this to go to Superior Court, and Superior Court say there was a procedural error, send it back to the Board of Adjustment and Appeals.
we still have a meeting.
So
We don't
there's
say we're meeting.
some question about whether the public hearing was open at the conclusion of the November 3rd meeting. Okay, so
And that's from the appellant.
we should reconsider it so that there's no question. And then the question is, if the public hearing is open at the conclusion of the November 3rd meeting, and we ask the town's attorney to provide guidance on specific issues, then we should receive that information in a public hearing. Otherwise, you're not correcting the perceived procedural error.
Well, we did receive the information on 4 questions.
But not as part of a public hearing.
They're in the appendix. I think we have discretion as to what we're going to discuss. We do not have to bring every single thing up, especially when Natalie was incorrect in some things.
Okay, so Natalie was incorrect.
So
There appears to be a procedural error based on her advice to us. We can either fix it or we can just stick to it.
how are we,
By just having the other meeting, opening it up, letting him address whatever number of issues there that were introduced in those letters, between the 2 meetings.
so that would just be the 4 questions that we asked her.
Yeah, we're not getting it from her. It's about what he has to say about it.
We don't have to ask him if he's anything about this. You do not.
We don't have to.
We can
But
just,
we'd like to avoid the
Why not?
procedural error that the appellant's attorney has pointed. So we're not gonna say, there's gonna be a
the
meeting anyway.
procedural error is not in they go on to say it's not in accepting more evidence from everyone. It's relegated to the 4 questions we asked Natalie.
Now,
Which-
the procedural error is that the public hearing was still open. at
Well,
the
it actually
conclusion of
wasn't,
the meeting.
because it's very clearly, I said that it was closed to public comment. And then we were going on to the discussion, and then Natalie got up and said, you probably have some questions. For instance, you might want a larger map, because I couldn't read the map. And then she asked us, we did not say to her,
That was like a map.
yep,
But we did ask for specific things.
but only
were-
when she asked us what she said, I
Yeah.
mean, we can roll the tape. She says,
Right.
you probably have questions. I
Right.
do.
And I did.
So therefore, we were thinking, oh, well, what can we ask her? Okay, we can ask her to get us a better topographic map. We can ask her about the conforming and non-conforming lot, and about, I can't remember, whatever. About the overlap, if there's any overlap between shoreland zoning and regular zoning ordinance. And if so, which trait takes precedent? Yeah, I'm just telling you what, I just watched the video.
Is that what the question was, that was presented? Because
Yes,
I think it's always
do you,
the
do you,
stricter one
do you want
applies.
to, right, the stricter one applies.
Okay.
But she was saying that there's no overlap between the two ordinances, which is ridiculous. So
I don't know what, that was in the context. of what
it was in the context of
which
asking,
issue was in the overlap,
well, let me just,
what the,
it was because we were pointing out, she was saying, I'll keep it to the shoreline zone. Unfortunately, you have to look sometimes at the zoning ordinance to determine the lot's characteristics. You can't just, right, look at the shoreline zone. So that's why we were asking her. And she then sent us the memo that was apparently 2 days, like 2 days before the hearing, that said, there's no overlap. But of course, there's overlap. Otherwise, each ordinance wouldn't say, like in section 20 something, in the case of overlap, the more restrictive provisions will.
I know, but I
Apply.
still don't know what the issues in the shoreline zone are water frontage, that's a measurement. And then the other one is, given the topography, where do you measure the bluff? Those are the two issues, and they are covered by the shoreline zone, and I don't know about the other, what's the other overlapping question? Is that, well, if you can't build anywhere on the lot, how can you build on any part of the lot? So
There's that.
is that, but, you know, what are the, if you don't have road frontage, if you don't have sufficient road frontage, you know, how much land, additional land do you need? It's usually 3 acres for back, you know, for back lots. You got twice the acreage, and here we have 2.1 acres. Like there are issues like that, but they're not like vague things about things overlapping that we can't.
Well, they were pretty kind of like,
Well,
then
maybe
we,
if we kept just to the specifics.
the 4 things that we, if we're going to keep specifically, we can discuss them right now and decide whether there is a need for reconsideration. I'm just trying to find it.
Which one are you trying to
I'm
find?
trying to find one of the million.
What is the applicable shoreline zoning ordinance?
We didn't ask her that. She asked us, she posited that there were probably questions we had, and she said, like, you'd probably need a bigger topographical map, because even she couldn't read it, and we all agreed that we could not read it, and she said she would get one. Okay, so that's number 1, a better copy of the Owen Haskell plan.
Okay, but closer to my interest is, if a lot is created, say a hypothetical lot is created in 1988, and Cumberland adopts shoreland zone in 91. And the state, there was a statewide law of 100. I guess I'm just wondering what, in the shoreland zone, which of those is there? See, I don't even know this. This is how, erudite some of the, or not erudite, but some difficult some of the stuff is. I don't know if the fact that they adopted it in 91, I know it applied to like the Gil Martin review that we did of that. But I don't, was the 150 feet a requirement of the general state requirements everywhere at that point?
Yes, there's state requirements that were mostly adopted, like the shoreline zoning, I guess, I can't remember, like 2007 or
But
something.
can one be
The state
grandfathered into
required you to
shoreline
have-
zoning?
Yes,
Yes, so,
from this lot, from the standpoint of the shoreline zone ordinance, is a non-conforming lot. Because it was created prior to the town's effective date of the shoreline zoning ordinance, which is 1990 or something like that.
But 1991 is when Cumberland,
Effective date, December 10th, 1991.
yeah.
And the lot was created in 1988. So for shoreline zone purposes, it's a non-conforming lot. I don't want to go into anything further about what its status is under the zoning ordinance, because that's not what we're supposed to be doing.
right, so number two, the second question we asked Natalie, because she solicited questions from us, not because we necessarily wanted these questions. She said, what are the dates for non-conforming lots, which it's August 1st, 1975. Anything created after that.
That's
it's not
under the
conforming.
regular ordinance.
It's also in the shoreline. I think.
No,
So-
it's 91.
So it's that, she provided that answer. Review of deeds for original lot 7. She did not really do that, but because the answer she gave was wrong. So the fourth thing is the accessory structure in the shoreline zone. She said, yeah, it's in the shoreline zone, but we had already sort of figured that out. Everyone, admitted it was in the shoreline zone. So those are the 4 questions. Do we still have questions about whether it's in the I mean, I think, great, neat questions. They, in some ways, were not, we based our findings on what happened or didn't happen with the shoreland project permit application.
Yeah, right. It was
So
submitted without the documents that were required, because this is it's not an easy bill.
But they're not required, Charles. We can ask for them. We could ask
I'm
everyone
I'm
to.
saying that the plot plan, a scale plot. plan
Oh, I see,
Of all
yes.
of the development of this lot was
Right.
really needed, and all this could
Was
be avoided
required.
if it had been done.
Well,
It was
exactly.
required, it was
If the
required.
McKees had followed the rules for applications for shoreline project permit application, and if the code enforcement officer had adhered to our ordinance, all of this could have been avoided, but that didn't happen. They are both culpable. So that's what we found, and we stuck to the 4 or the 3 things that are irrefutable, as Tad says. So we can review this till the cows come home, but it's not going to change the fact that as Cheryl said, I'm trying to find Tad's thing, that we,
And we have to correct the procedural error.
no, we don't.
Well, we don't, but we'll correct it at some point.
I just have a feeling that it's gonna come back anyway.
Right. Might as
So
well fix
no
it
matter what we do, it's gonna come back. It's like a boomerang. So that's not something that I'm worried about. This thing also came in well after the time for the window to think about these things. I mean,
It was also
Enough.
brought up in other letters that did come in within the 10 days.
well, not the procedural area.
It's the same thing.
No, it's
They're-
not the same thing.
Yeah, it is.
No.
Yes.
Because I clearly closed it to public comment. What our town attorney did to us,
But there is confusion over that, and
It's-
that's what the procedural issue is.
well, then that rests with the town attorney, not with us. So I would say we followed the directions as we were supposed to. We made the conclusions we did based on,
And yet, if there was this procedural error, she wasn't running the meeting. She doesn't run she is there talking just like anybody else. She's not, if there is a procedural error, it's our error. It's not hers. We could have sat her down, we could have said, okay,
Well,
Sit down.
if the meeting was closed to public comment, everything that she said shouldn't have been said.
or it was just advising us. At that point, it was closed to public comment, and yeah, technically, she's the public, but I think she was advising us at that point. So it then, because we were going to go into deliberations,
Okay.
and it was just too overwhelming.
And you're saying you're saying that Sandra is incorrect
I don't
in
know,
her,
she wasn't even there,
well, I know, but she reviewed it
so did I. So did Tad.
So,
I mean, you could debate what the tape shows.
It's-
I
some
hear,
of it's
I hear
very hard to
Sam
hear.
saying, I think that I should close public comment, and then Natalie gets up and starts talking, and it's almost like,
I mean,
she's
we
trying-
can
it's
watch
almost,
it,
it's almost like she's saying, wait a minute, don't do that, because you still have all these questions.
and
What
yet she
we
was
were
the one
told-
who advised us before
Well,
the
what we
meeting
were told
that we
in
could
the,
close the public
that we were supposed
hearing.
to.
It's not,
No,
it's not
we were-
public comment.
No, we were
No,
supposed.
public hearing is one thing, but
No,
our
you're-
deliberation,
No,
no, that's not the term of art.
it's, the term of art is, because we went over this in our workshop. We close the hearing to public comment. And then we can proceed to deliberate. But in the meantime, and Natalie got up after I said we had closed it to public comment. She got up and asked us if we needed anything. So you can assume that she is just talking to us as a board about to go into deliberations. And then people just started getting up and talking out of turn. They had no right to get up, but I'm not real pushy usually, so I just, was somewhat looking to Natalie to make sure we were doing everything right. But
Right, but I
we
don't
had
think,
closed it. It was.
but I don't
this-
think Mike got up.
Actually did, yeah. He's in the background saying something. I don't know what. And, yeah, because it goes on for like another 10 or 15 minutes, because she goes on and just questions us. And then, you can watch it. It's not very entertaining, but you can watch it. But she is talking to us at that point. She's not talking to the public.
About what we need in order to go
Yeah,
into
but-
deliberation and make a decision.
Exactly. She's asking, do we need anything?
Right.
And so we said, well, we may need clarification on these 4 issues. She's the one who brought up the map, but we can't disagree because it was pretty hard to read. But she asked us, what do we need? The public was done, so I don't think there was any
So there's now a
procedural error.
legible map.
I actually, when I looked at it on the selectmen's packet today, I could actually read what the notes said. I was surprised. But the
But
notes
yet
say,
we didn't really touch on any of those.
well, because we had other things. I think if we had,
we did not go on, comment on the slope issues, the coastal bluff,
No, because.
deforestation, revegetation.
Right, we jettisoned a lot of that. I mean, there were a lot of problems with slope and soil disturbance. There was the fact that an unpermitted contractor was allowed to work on this project and supervise this project. And the DEP was never contacted, there's nothing in the file. I mean, we based our decision on what was in the file, which was pretty darn sparse. And I mean, when you're applying for a permit, you have to rely on people's ability to read.
I just keep coming back to the fact that I think, and the appellants, one of the appellant's attorney also thinks that when you review the video of the December 1st meeting, that it appears that the board had made a determination to hold the public hearing open.
No,
It appears that way to
Let's
me,
watch
it appeared that way to her,
right here,
and she
So
wants
we'll
us
go-
to correct that procedural issue.
right here. I did exactly what we were supposed to do. I asked everyone, like, any comments, any more comments? And David Hill said, yeah, why are we here? And then I said, so we'll close the meeting to public comments.
There's no motion, we didn't vote on it.
No, but you can say that. We don't have to vote on it. We can just close it according to the Board of Appeals manual. So, blah, blah, blah.
I don't know, I just,
So we closed it and then she advised us. I just said it right there.
what'd you say?
I said we should close the hearing to public comment. Yeah, I
We
mean,
should.
and yeah, we did. And then Natalie got up and you can see her ask us, do you,
I thought you would have to make.
And the minutes
I don't
don't
think we
reflect
have
that
to
we
make a
closed it
motion.
either. So I think that this.
so
procedural
here's
issue,
this, yeah,
I think this should reconsider.
reconsider based on these four issues that we don't really need clarification. I mean, we have to only include these four issues.
I mean, well, yeah, but it's also made clear interest. Okay, you're saying,
Otherwise, it's another procedural error. I mean, we can not, we have choices according to Natalie. We don't have to reconsider at all. We can reconsider very narrowly. We can reconsider very broadly. We can start the whole thing back on day one. The town attorney did not say we had to make a motion to close the hearing to public comment. She just said you have to close the hearing to public comment. And she made it very clear that we couldn't close the hearing because that would mean it was over. So she differentiated between the two. I wrote it down and then looked up everything in the Board of Appeals manual so that I would not mess it up. So as chair, I closed the hearing to public comment. If that's wrong, then I guess the Board of Appeals manual, Maine Municipal Association manual is wrong as well.
And so is the attorney for the appellant and the people that asked us to reconsider.
Right. It also says that we can make our own rules in according to how the hearings go. I mean, I'm with Tad, no matter what. We can discuss these 4 issues, get more information, but they're not going to change the reasons we denied the permit. That's
No, I
the
can't
big-
imagine that they would, but I don't know what information has not been presented. And if we keep it to those 4 issues, then no other information will be presented.
Not a problem. That's why we had a public hearing, so that people, as Attorney Richard pointed out, that's your chance for due process. You come prepared to answer all these questions, just like the Gallagher attorney came prepared, came with slides, came with documentation.
Yeah, but they also submitted a packet of information to us on the day of the next hearing. And the McKees were not given the opportunity to respond to that.
We got it 2 hours before.
I know, but they weren't given the opportunity to respond to it.
They had the same 2 hours we did. I would.
Well, we had a whole
suggest-
meeting.
No, we had 2 hours to look at that memo. We had like 2 days to
No, but
look
the
at.
point is, then we had the meeting.
Right.
Okay, well, then we had the meeting. We're not, we're not gonna get more information out of these 4 questions, which is,
However, the parties will be allowed to participate with that information and to ask questions of it. If there's something that we don't know, I want to know it.
well, we don't know everything. We based our decision on what was known. And I think the place for this is Superior Court. It's not here. We're not lawyers. This was a really difficult thing. And we have, neighbors
I
hating
know,
our
but
guts
that
for
same
doing
difference
this.
is
So,
that We got this lawyer here,
Okay,
the
but that's,
appellant here, saying that there, that there could be this procedural error.
okay, there could be.
And, I don't know what his point is. He's not here to tell us, is it? So, it
Are
was
you
just,
Sandra? We've been talking about
I
it.
know, it is good.
I don't know if it's allowed to talk or not.
No. Well, we can ask her a question. It's our board meeting, but,
Well, I don't know, so ask it.
I mean, we're not lawyers. It's procedural error. This is the kind of stuff that needs to go to court at some point to, like the whole Rule 80A. I had to, or whatever the hell it was, I had to look it up. I don't know what it was. I still don't know what it is. We were asked to look at something and rule on it based on what our ordinances say. So we did. End of story. If these people want to argue about it, the place is no longer here. They had a chance in the administrative appeal. We made it clear, we were starting from scratch. You present what you have, you give it all you got at that public hearing. And if you don't come back for a second bite of the apple. It's just, I mean, you can try, but it doesn't work. You were supposed to come prepared to that hearing. That's why we put out notice and make sure everyone's informed. So if you're not, the onus is not on us to make excuses for people who aren't prepared. The onus is on the people to be prepared. I mean, we are a quasi judicial body, so our decisions carry weight. So when you come to this, an appeal, be prepared, because what you say matters. Doesn't matter, you can get up in town meeting and say anything you want, and people will agree or not agree, but it doesn't carry the weight that our decisions do. So take it seriously, and when we ask why you had an uncertified person doing all the work in the shoreline zone, you damn well better have the answer. You say, oh, I checked his certification and it was current, or I didn't check it. But this whole, like this casual thing, I didn't know the answers, but I'm gonna do better next time. We came with the answers. We spent a whole month thinking about this, or at least, I mean, afterwards, it turned out that Cheryl and Tad and I were thinking about it. I don't know if you were thinking about it. Not going to impute thoughts to you, but we thought about it a lot and wrestled with it. I prepared the findings of fact as we do for hearings. We then went through them. If we didn't like them, we threw them out. If they were wrong, they were corrected. And then at the end, Cheryl proposed a very narrow, but I think Tad's right, ironclad reason why this permit shouldn't have been issued. There's nothing that's going to change the fact that the permits were not properly, the applications were not properly processed. Or, I mean, again, the rules were flouted. So do we give everyone a chance to flout the rules? I mean, you're a builder, Charles. You think,
I'm getting way beyond.
okay, but I'm just saying,
Let's
yeah,
just keep it. That's not, that really isn't my concern. So
only
there
here,
is,
it's
we
not.
have, it seems that if we don't decide to reconsider, or it doesn't mean we can decide to reconsider and not reconsider at all. I mean, we can approach reconsideration. Doesn't mean we have to change anything, and it doesn't commit us to any particular thing. It may make this process. I guess in some ways it's not going to, if there is no procedural error, if whoever reviewed that,
She's right here, you want to ask her?
I don't know that we can we in our deliberations right now?
We can, it's just a board meeting,
Oh, it's a board meeting.
so we could ask a public what that even means, but,
And then when we do that, then
okay, well, then we don't. We leave it a mystery what she meant.
I don't have the answer.
I don't have the answer, but it came in at the 11th hour, and at a certain point, actually, you know what, Charles? We have 45 days from the initial decision. We don't have that 10-day window to ask for reconsideration. The board itself has a longer window. So if we really want to reconsider, we can have another meeting and talk about why we would want to reconsider. I am very reluctant to do it without Tad, because Tad has been pretty clear that he does not want to reconsider. But we can have a meeting next week and talk about why we would.
I'm not sure what you're proposing.
Well, I'm just saying, we can
To have
table
another meeting to decide whether we're going to reconsider.
it. I mean, at this point, we can vote not to reconsider, but we can reconsider our vote.
I would like to hear from Sandra. How do you pronounce your last name?
Okay.
Gay. I would like to hear that, you say it is my opinion that there is a procedural error here that should be corrected in the event this matter is brought to the Superior Court pursuant to Rule 80B appeal. So I would like to know what the procedural error is and how it can be corrected, in your opinion.
What?
If a board wants me to, I have comments.
Yeah,
Sure, so you just have to read
But
next to
can we keep
that.
it specifically
Yes.
to what she
Only-
did wrong on the video?
Right.
That means that
Definitely, yes, I will keep it to that. Sandra Gay, Archipelago Law.
No, right here, it's fine.
And yes, I wrote that letter. So I was not at the meeting. I did watch the video and discuss it with Keith Richard, who's also in my,
There we go.
in my firm. So at the conclusion of the video, I believe that I heard the chair say that the public hearing would be left open to the next meeting. So, and there was no vote, and there really should be a vote to close if it's going to close. So because of that comment that it was open, was staying open to the next meeting. And it was not after that point, then officially closed, it left that public hearing open.
I can respond, that's what I was told
So-
to say by the
But
town
the second,
attorney.
what part of that question is, how do you correct that?
So you correct it either by, well, if you could just open and close the public hearing, but you've already voted on a decision. So the only way to open and close the public hearing again is to reconsider. And then as Attorney Byrne suggested, you can open and close the public hearing. You can take more testimony. I feel limited to those 5 issues. I understand that, Mr. And it actually, per memo, if you look at it, there were 5 issues, not there was my error. But just,
Okay, well, that's your error, but how do we know you're not wrong on this first part?
were you lying then, are you lying now? Because that's procedurally, for my many years of doing this procedurally, that's, if you don't close a public hearing, it's still open.
We were told not to close the public hearing.
Okay.
I can show you our workshop. No, I closed the hearing to public comment, but I was specifically instructed by the attorney not to close the public hearing, because that would mean it was done.
And
So,
that is the motion that was made, was to continue. the
Right,
public
right,
hearing.
Right,
So-
so I'm not gonna, I mean, this is a deliberation for you, you just had a question for me,
Yeah.
so
so that's.
what I see is the procedural error is that there was a comment made specifically to leave the public hearing open, it was never closed after that. I just wanted to point out in your rules, all 3 of you need to vote, if you do decide to reconsider,
Right,
all 3 of you would need to vote to do that under your rules.
right, we're just still.
All 3 of us would need to vote one way or the other. Is that what you're
No,
saying?
in order to reconsider, under your the reconsideration of a decision shall require a positive vote of the majority of the Board of Adjustments and Appeals members originally voting on the decision, so I believe there were 4.
So we would all have to
4 of us.
agree.
So you mean Tad would have. Tad
No, because, so there were 4 people that originally made the decision,
Yes.
so 3 would need to vote in the affirmative to reconsider,
The majority of the 4 that made the decision.
just to avoid a
Quorums.
procedural. Yeah,
Madam Chairman, point of order, please.
No,
You were given
No.
the appellate attorney.
no,
Wait,
excuse
wait a
me,
minute.
You're not
excuse
gonna
me.
give
We, this is our board meeting.
We asked
Point
her
of
We
order.
asked a question of her
and she answered it.
and she answered, and that's it. So. Well, all I can say is we follow the town attorney's advice. if it's procedural error. I would feel more comfortable with Tad weighing in. I would feel more comfortable with Tad weighing in on this decision. But he can't be here because he's isolating.
Okay, so then. Want to wait till Tad's back?
He said he could be back on Wednesday. I mean, we can call him, but I don't know if he's been listening to this, so we can't. So I think that the question for us is, if we don't have Tad here, are the responses in Natalie's memorandum going to make us change our decision? I think Tad is right in that we have to go back to the fact that we based our decision on three things. I'm trying to find it now, that Cheryl proposed, and I think you seconded it. Right. So we based our findings on those. It did not come down to those 4 questions, as a matter of fact. So
Are you wanting to know what the 3 things were? that
Yeah,
required
I
that were
wanna
not
just-
submitted?
yeah, and let's look at it that way, which is what Tad had suggested to us. So let's get what we said in the hearing. So I think this is the letter that Tad sent out, which is the decision based on the findings of fact and conclusions, the town of Big Island Board of Adjustment and Appeals voted 4-0 as follows. The appellants have demonstrated that the time for appeal should be enlarged, 4-0. The code enforcement officer's approval of a shoreland project permit application for driveway extension and guest house site 22 SC2 is reversed, 4-0. So this is your motion. The first motion was there is good cause to enlarge the time for appeal, proposed by Cheryl Stevens, seconded by Tad Rumsey. We voted 4-0 that there was good cause. The second is the code enforcement officer's approval of a shoreland project permit application for driveway extension and guest house site, 22 SZ2 closed parens, is invalid for reasons including the lack of a scaled plot plan, the lack of a written erosion and sedimentation control plan, and the use of an uncertified DEP contractor, proposed by Cheryl Stevens and seconded by Tad Runge. That was what we decided. Is I think nothing that can be said about those 4 questions for Natalie are going to change those facts.
No.
So therefore, we're on pretty solid, this decision is on solid ground, as Tad said. And I agree with him. These are what we decided. We did not have to, we did not consider invalid, non-conforming, conforming lot. We did not go into the resource protection thing. We just considered these
Or the
things.
bluffs. George Hayden,
Or the bluff. Right, we didn't consider any of that. We put the three things that are irrefutable and weren't done. So I think,
I agree. I don't understand why there's so much confusion about how we reached our decision when really what we were doing is de novo review, which means we go to the ordinance. The ordinance says you have to provide these things, and you look to see if they're there, and they're not.
yeah, so I think it's pretty clear cut. We didn't. I will read you one quote from Toomey versus Town of Fry Island, 2008, Maine 44, 943A, period 2, must be second, 563. Substantial evidence is evidence that a reasonable mind would accept is sufficient to support a conclusion. That inconsistent conclusions can be drawn from evidence does not mean that a finding is not supported by substantial evidence. The burden of persuasion rests with the party wishing to overturn the
I
municipal
really don't
decision.
know. I mean, that's nice.
That's
Maybe
why
that
I
would get
didn't
you in a
go to
book
law
on law codes.
He
But
did go to
that's-
law school. But anyway, so
I got the
it's,
highest grade in legal reasoning that you know.
okay, so that's why you're here.
No, yeah, that's why I'm here.
Yeah.
But I-
Instead of there, instead of sitting with Sandra. So I think we have to come back and say, would our findings, our conclusions, our decision were based on irrefutable facts and findings? We didn't, all the universe of questions that were encompassed in those 4 things or 5 things that Natalie was asked to do, didn't figure into our decision.
Okay,
So,
and so our decision, and you're clear that our de novo decision, our administrative
administrative appeal,
appeal, that we've satisfied that.
yes,
And that so these other, some of these other issues that, the better copy of the Owen Haskell plan. We didn't need that because we didn't go to the slope.
exactly.
We didn't go to
We
the slope
didn't
thing
go
or
to the
anything.
slope thing or the resource
What are the
protection.
dates for non-conforming lots?
We didn't need that either. We didn't
Review of
consider
the
that.
deeds for original lot 7.
I think the attorney Richard supplied that finally for us, not,
But was.
but it doesn't matter because that was, it was.
No part of our decision is based on that.
Exactly, that's the point. Those points that we asked, those questions that we had of Natalie, none of our decision was based on any of those questions.
Although some of the answers to those questions are in the findings of fact.
Right, but we didn't, you can put these findings of fact, but we ultimately, what we voted on was that the shoreline project permit application should not have been approved because of the lack of a DEP certified contractor, the lack of a scaled plot plan, the lack of a written erosion and
Right.
sediment.
I know, but that's the conclusion.
Yep,
And are you sure that every single one of our findings of fact is actually
Okay.
not under contention and not requiring additional testimony?
it doesn't matter because we
Except that
didn't.
we're providing it to the court, these findings of fact.
Yeah, these are all this is the universe of things we considered. And remember, we jettisoned about 2 pages on the erosion control, the tree removal, the denuding of the lot, all that jettisoned because we thought we had enough with these 3 things. Just very simple things. These directions, these requirements, these ordinances were not followed. So that's it.
Why all findings of fact that don't have anything to do with them? It's you're interjecting stuff that can be argued with or whatever. It seemed if we had these very simple conclusions, they needed to be based
Well,
on.
that's what we did in our discussion. We boiled it down to this.
Okay,
And
and
so-
I asked again, is there any value in looking to see if there are any findings of fact that are not, that are still under contention, that we don't have an answer to?
We don't care, Charles. It's like saying,
You don't
no,
care.
we based our
I'd rather
decision
be right.
on these three things.
We did base it on those things.
So-
We also, I think that there is some way, we said the way the argument is structured is based on the findings of fact and these conclusions, or they are referenced.
Well, that's
there's
what,
something in there-
like, I just cribbed this from Peter Rice, okay? Because this is the second time I've ever written these
I
things.
know.
So
And
I
this
got it
is-
from
and this is
Peter,
the
and
first
Peter's a
time for a lot
lawyer.
of people.
So that's why
It's
it's
the first
this
time for a
way.
lot of people here, and so allowing for, you know, I just don't think that.
No, I think it's like apples and oranges now. It doesn't matter. We voted on this narrow.
Yeah, but what
finding.
Charles is saying is the findings of fact went into more detail than that.
It doesn't matter.
And maybe they
I mean,
shouldn't have, right?
Maybe it shouldn't have, yeah.
They're pre-hearing findings of fact. That's all.
Yeah, but that's not pre-hearing findings. of
Or
fact. Those are
hearing
No,
findings
findings.
of
usually,
fact.
They're
Peter,
findings
usually what
of
we did
fact.
is we voted on the conclusion, and then we drafted the supporting finding of
No,
facts
we came
underneath
in
it.
with this
So we
stuff.
didn't have a whole laundry list of stuff, and then conclusions based on, you know,
We
with some
had this.
extraneous.
Because I looked at a lot of Peter's things, and I was there, like, I've been on this board for at least 8 years with Peter and Tad and,
But wouldn't
Your
you think that
husband,
it might be, if,
no,
if we were thinking about, you know, the public perception
I don't care about the
of,
public perception.
of government,
I really don't, that's not our,
that we would,
Again,
if we
not our
had
daily-
findings of fact that we had any doubt about, that we published as if we didn't have doubt about it, that it would be good, especially if it's gonna be remanded to us later anyway, or could be, probably will be anyway, whatever.
it's not what we based our decision on,
I'm,
so you have to look at that. I mean,
no, I don't have to look at, I
Okay,
can
you
look
don't
at
have
the
to
whole
look
thing
at it.
however I want to.
I don't think I actually ever got a copy of the final findings of fact.
it was as edited, it had to go, here's
I requested it from
copy.
Ted, something from.
Oh, I don't have one.
No, it's in the public domain.
But is it publicly available
It is.
on the website?
Yes.
All right.
And it's in the select board's packet for Wednesday, I would think. It's like, but. Yeah. Are we sure of our original decision? That is what we're asking.
Are you making a motion?
No, before I make a motion, I want to understand. This was our original decision. Are we sure of our original decision? I mean, I can reread what Tad said about it. It's pretty solid.
I don't need to hear what Ted said about it.
Okay,
We read it a couple of times, and I think Ted has in a hospital administrator for much of his career. And now at the road salesman, he's not here, and we're here talking here, and so, you know. And he has not witnessed this conversation. He hasn't been here with us talking about this, because we couldn't. So, anyway. I'm still of the mind that I don't see how we have, you know, this, you know, I don't don't see how it's gonna hurt us to reconsider.
I don't either, and
How?
given
will
the
it
number of
help
people
us?
that have,
And
can I finish, please? The number of people who've asked us to reconsider, I personally don't see any harm in reconsidering.
reconsidering on these issues that Natalie was asked to provide.
I think
I think
reconsidering
reconsider on more than that.
on
And not
any,
to say that that I think we're gonna change anything.
on
I'm just
anything.
talking about, I do think that that it would be good to hear beyond that, as long as it sticks to, issues of fact. And not, if there are factual issues, that we can base something on outside of just an appeal, to heartstrings.
We don't have an appeal. I mean, this is just pretty straightforward. We looked at what was deficient in the shoreline. Natalie told us to stick to the shoreline zone. So we did. She told us that we had to bifurcate the hearing, and the first part had to be about the good cause thing. So we decided that immediately, and then went into the second part, which was all about the permitting process, and we found these deficiencies. Knowing the resource protection thing is not an issue. It's just something, we decided not to base our findings on that. So it doesn't matter.
Okay, and yet we had this, a difficult subject,
Right.
and we had limited legal counsel. We couldn't talk to each other, right? The whole thing,
It's messed up.
at one point, there was there was the discussion about whether or not we would get counsel, independent counselor, lawyer from the town. There were obviously,
Well, we
I'm
can
just saying, the
stop.
whole thing, even the procedural issues. It does seem that it could be perceived to have been rushed. And I wish that wasn't the case, and I wish, I wouldn't, people coming and talking to us for. As George Hayden did and other people have done. But I don't, if there is procedural error and the appellant lawyer is saying, okay,
You really have
we
to
should.
do the
we
whole
should
thing
straighten
all
this
over
up.
again.
We do have to do well, I don't know if we have to, I mean,
I
it doesn't
think
mean
so.
it's gonna change.
That's
It
the
doesn't mean it's
problem.
going to change. I mean, what is the whole doing it all over amount to?
Well, it's just following the same agenda we had the first time, where, somebody presents and then people can ask questions and then
Well, if the
Helen
hearing is
presents,
all,
the applicant presents, the code enforcement
Could be
officer
de novo.
presents.
We start the whole thing from scratch. Is that, you think that if we do that, we will still,
well, how would we start, if we never
You
closed the
just-
hearing, why would we start new? If the hearing is, if we didn't, well.
I
think
mean,
she already
that's
asked that.
her opinion. Did what our attorney told me to do in the workshop. Was very clear on that. So the attorneys can duke it out as far as I'm concerned. I did what I was supposed to.
Well, I don't think we're gonna get 3 votes tonight to reconsider. And that's what we have to do in order to reconsider. So what are our other options tonight?
Go back to now, this thingamabob.
Someone has to make a motion. Someone has to make a motion on whether to reconsider. If a motion is made to reconsider, then we have to vote on that motion.
I make a motion to reconsider.
I second that motion.
All in favor? Opposed?
So we have tabs written.
Opposed.
No, well,
Yeah, you
no,
don't have a-
Opposed, right.
yeah, all three of us have to vote
So,
Yeah.
in the
Yeah.
affirmative.
so
So the motion did not pass because we needed a majority of the board that made the original decision.
So there's your answer. And just to know, we don't have our secretary tonight because he's sick, so no one's taking notes.
But watching on YouTube.
But no one can take notes and think about this separately. It's an unfair burden on Tad to ask him to think about these things and to be writing madly his notes. And he misses things and he is not happy about it, but does a pretty good job. Okay, well,
So
it does not pass.
would you like to make a motion to adjourn?
I think we'll make a motion.
I would make a motion to adjourn.
Second. All in favor? Okay.
So didn't have all four. Still made the decision.